And we say good morning, good morning, good morning. Welcome back to Sunrise. It's time for another segment of Law and Order JA. The question sent in to us today, MPG, reads as follows. With all the conversation happening around Vybz Kartel's release, would he have a case against the state for malicious prosecution and or false imprisonment? Criminal defense attorney at law and managing partner of Blacklaw and Associates, Ludlow Black, joins us this morning to break down all the legalese and the legal jargons to help us understand what's at stake right here on Law and Order JA. Welcome, Mr. Black. How are you, sir?
I'm great.
Very well, counsel. Now, lots of people have been asking the question because now that he is free out in these streets, what's next for Mr. Palmer in terms of a civil suit?
All right. I think that the issue of a malicious prosecution suit might not be the best thing for him to do at this time. Reason being that malicious prosecution is a very difficult tort to establish. He would have to prove, as a claimant, would have to prove that the prosecution was initiated against him. It was done without reasonable and probable cause. It was resolved in his favor, which he's acquitted now. And then now he'd have to prove malice on top of that. So to get over those hurdles is very difficult.
And in his case, because there was forensic evidence, there were witnesses, so the state can say, but listen, this wasn't a frivolous case, right? We had this amount of evidence, we had physical evidence, forensic evidence, witnesses coming in, and we had a trial, so where is the malice aforethought? But just for our viewers, Mr. Black, what is malicious prosecution and false imprisonment?
Well, malicious prosecution is really when the state takes action against you and they did it in a way that is not proper, in that they had no grounds, no honest belief that you were guilty of anything, and they continue to press on with the case nonetheless. False imprisonment is a little bit different. False imprisonment is when you're arrested and locked up and there's no grounds for you to be locked up. You're just there languishing longer than the constitutional time that you're allowed, which is 72 hours. So that is the really distinction. I think that persons might look on and say he could make a claim, but knowing the law and being aware of it, you know that the nitty-gritty is there, that you can't get around. However, there might be something for him to go on as far as constitutional rights, a constitutional breach. That is something that the Court of Appeal and the Privy Council echoed, that, hey, the constitutional right was breached given the issue with the jury.
The poison.
And so I think that might be an angle for him to go on. What his damages might be is for us to wonder and to think about. We're not sure.
I am curious because I'm pretty sure that Mr. Palmer may not even have known that these words actually existed prior to now, right? And he's necessarily being advised by somebody, by a very capable legal practitioner. So I want to find out, because it's one thing to look on a case and to draw conclusions from a general perspective. But is it possible that there's some kind of a loophole or leeway or caveat? I don't know. Is it possible? Because why would somebody, is my question, why would somebody who is excellent at what they do in the legal field advise the gentleman to pursue this?
Well, it's difficult to look behind what happens between counsel and his client. You know, he might be advised as counsel that, hey, I want to take this action. But counsel's duty is to advise him based on the law that, hey, this is the likely outcome if we approach it this way, and this is the facts of your case. Just to lay things on the table. Whether or not it's successful, yes or no, will boil down to whether or not the client wants to push on with the matter. But looking on, I wouldn't mount a claim like this. I don't think it would be successful.
Meritorious. Talk to me, counsel. In terms of malicious prosecution, what, if successful, what are the possible relief that can be given or granted?
Well, he could get damages. They would assess the time that he's been in custody. He's been in 13 years.
30. Well, he says, no. He said, nah, get the government 2 extra months. It's 12 years, and I say 6 months. So be very clear about that.
So that length of time would have to be assessed based on previous case law to say what's the damages that he should get based on the breach and based on the suffering that he would have gone through during this time, the quantum. So that would be the key, and that would be mainly the damages, really. I don't think there would be any other real thing that he would want outside of that. He wants some cash in hand from the government. So yeah, that would be
Okay.
Interesting.
Interesting. All right, interesting. Because a lot of people have been asking, and people automatically think that because you're freed, then malicious prosecution follows, and it doesn't automatically follow all the time.
And that's true. And Kartel is of age, is older now, more mature now, coming out of the system, and he just came out. Maybe you should just breathe a little bit and take time to collect yourself and then decide, hey, this is where I want to go. I want to take a constitutional claim. I want to go malicious prosecution, whatever it is. But take the time to breathe and really reflect on it, get proper advice from your counsel, then you act.
You know what's interesting? We can speak from the perspective of the free.
Yes.
We have never gone anywhere and done any time.
That is true.
No, one of the things that he reverberates since he's been out is the idea that he's lost time. Time has now become the essence of everything, right? So if he wants to do things expeditiously, he's kind of sort of justified, because I feel like he thinks that he may have lost so much, and he
doesn't want to lose any more time. Yeah. All right. Well, for those persons who were asking the question, I know for many Jamaicans, that terminology has been banned about, and you must sue the government. You must the government have to pay a whole lot of money now, whole heap. Maybe. Or maybe not. But that is a matter for Mr. Palmer and his attorney or attorneys at law to decide. It is definitely something that can be pursued. As to whether it will be successful, that will be left to the wisdom of the judge. But thank you, Mr. Black, for enlightening us and giving us, the 411.
I'm the novice here, so I'm gleaning from both of you.
No, well, I'm being counseled as well, so, yes, when senior counsel, you take the guidance, right?
I get it.
So thank you so much, sir. Have a beautiful day. So that was Ludlow Black, criminal defense attorney and managing partner of Blacklaw and Associates. Coming up next, the poor people's lawyer, the inspirational Diane Jobson, joins me right on the couch. You don't want to miss it. This is CVM Sunrise.
Bye-bye.